you want to pursue a career as a paralegal in America? According to the United States Bureau of Labor Statistics, the median salary for a paralegal in America is $59,200 per year. With a growth rate of 14.1%, there were 354,300 new jobs in 2022. Join the Paralegal Bootcamp program under the direct supervision of top American attorneys and pursue your dream career as a paralegal. Not only will we educate you on the American legal system, but we will also help you find your dream job. For course fees and other information, please visit our website at www.paralegalbootcamp.us.
Hello, everyone. Thank you very much for joining today. So today we are going to have a very special session on investment-based immigration. As you already know, there are two major categories in investment-based immigration. One is EB-5 and another one is E2. So today we have two very renowned attorneys. They will talk about EB-5 and E2. And after their presentation, you will be able to ask questions. We will try our best to answer all of your questions today. Just as a housekeeping, so this is not a legal advice. The entire show is for the purpose of information only. Please do not consider anything that we talk here as a legal advice. If you need more information, your tailored advice based on your situation, you have to contact us and we will be able to help you for your dream application for investment-based immigration. Without further delay, I would like to invite Benjamin Hu. He's a great friend of mine. Benjamin and I were co-chairs of Montgomery County Bar Association Immigration Law Section, and we do many other things together, many great things. So Benjamin is going to talk about EB-5. So without further delay, Benjamin, welcome to our show. Please go ahead, introduce yourself, and then talk about EB-5.
Thank you very much, Raju, for that wonderful introduction. I've been working with Raju as co-chair of the Montgomery County Bar Association Immigration Law Section for about half a year now. The time has flown. Very fruitful collaboration. A little bit about myself. I'm an immigration lawyer. I was born in the U.S. to first-generation immigrants, so I know the dreams and struggles that dream can bring. I've been in immigration law for just over a decade now. I've been working primarily in EB-5 immigration law. I did my first EB-5 case in 2012, and it's been a good 11 years since then. So very excited to be presenting today. And I'm looking forward to introducing EB-5 investment immigration and also helping to say a few words about E2 treaty investors. So I believe that we have a presentation all lined up for you. For EB-5 investment immigration, this is just an overview. This is, again, for informational purposes only. It's not for legal advice or guidance, and certainly not for financial advice. Let's jump to the next slide. So the overview, these are the moving parts of the EB-5 program. Number one, we'll have the investor, who is a foreign entrepreneur. This is the person who is not a U.S. citizen, not a U.S. green card holder, and they bring funds. They bring the money, and in some cases, they also bring the plan to create a new business. So that's number one, the investor. Number two is their funds, the money that they're bringing to the table. The U.S. government requires that these have to be lawfully sourced. So the investor must have a narrative, must be able to present documentation to explain where they come from and how it is all lawful. Number three is a new commercial enterprise. That is a business entity inside of the U.S., very important, must be in the U.S., that receives the investment funds. And then that new commercial enterprise then either is the job-creating enterprise or it gives the money to a job-creating enterprise. That JCE must create 10 full-time jobs using these funds that the foreign investor has made available. So as you can see, this is a program whereby the USA wants to bring qualified foreigners who have lawful money and who want to put that money into the USA and create 10 jobs in the economy. And of course, this is a reasonable endeavor. It's very praiseworthy. America wants to encourage this sort of behavior. And so the reward for that is a green card. There's two other concepts that we should cover at the very bottom here. We'll mention a targeted employment area comes in three different flavors: rural or high unemployment or infrastructure. And the targeted employment area brings extra benefits and bonuses, more bang for your buck, so it were, or in fact, same bang but fewer bucks. It gives you a reduction in the investment amount that you must make to qualify. The second concept is a regional center. Regional center is a way for you to park your money with another entity that you don't control, and that entity can help take care of your money for you during the time that you invest it. And this also has some rewards. It also allows favorable econometric analysis processes. Next slide, please. So what are the investment requirements? As we said, they must be lawfully sourced. You have to explain how they're lawfully sourced. And you must also show the path of funds. The path of funds is somewhat straightforward usually. It is bank documentation to show where the money comes from when it's in your control. Generally speaking, the lawful source of funds is going to be the primary legwork that you do in preparation for an EB-5. That's something that you and your immigration attorney will have to track back through your finances and figure out the narrative and present documentation. Now, the normal minimum amount is $1,050,000 US, $1.05 million. And if you invest that amount, it doesn't really matter where you invest it. It can be anywhere inside America. And as long as you create 10 jobs, then you have the eligibility for the green card. Now, importantly, that $1.05 million has been reduced to $800,000 US if you focus it in a targeted employment area. So the job creation has to occur in a rural census tract or in a high unemployment area census tract. So those things are very dependent on the exact area you're investing in and the data for that area, the population levels and the employment or unemployment levels of that area. So that's one concept. Completely separate from this, we mentioned regional centers. This is a choice that every investor needs to make for themselves. Do they want to do this as a standalone investment, or do they want to put it into a regional center? So there's a couple of different hypotheses and scenarios. A standalone investment is where we have the somewhat romantic Wild West idea of a foreign entrepreneur, briefcase in hand, an idea in head, and they come to the US with their money and they say, I want to create a factory, or I want to build a hotel, or I want to engage in some other lawful business enterprise that creates 10 jobs. So that would be a standalone. There's only one investor. There's no pooling of funds. You're not doing this with anybody else. It is possible for you to work with American investors. You can invest your $1.05 or $800,000 into the US and have American buddies helping you out, but you cannot have any other foreigner helping you hoping to get a second EB-5. A standalone investment only supports one EB-5, and that is your own. Or the second one is a regional center. The regional center is much more popular. It's much more numerous. Historically, I would say 99% of all EB-5 cases I've handled have been regional centers. And that is where another entity, a regional center, is entrusted with your investment money to take your funds and to mix it with many other funds, often with numerous other EB-5 investors, and then create 10 jobs per investor. Either way, regardless of whether it's targeted employment area or not targeted employment area, regardless of whether it's standalone or regional center, you still need to have the same results at the end. The proof, as they say, is in the pudding, and the pudding is creating 10 full-time permanent jobs for qualified employees. Next slide, please. So then for you, what does that mean? That means the EB-5 timeline for the investor is you're going to have to file the initial form. The form number is 526, or is 526E if you are filing with a regional center. That distinguishes the two, standalone versus regional center. And at the same time, if the investor is in the US and their country of birth does not have a waiting list for EB-5, they can also file the AOS, the adjustment of status. And that is a placeholder filing for Uncle Sam, for the US government, saying, Dear Uncle Sam, I have filed the I-526. I believe I'm eligible. I leave it up to you to determine whether or not I'm eligible. But if I am eligible, please automatically consider this AOS, which is my application for a US green card. So this is very powerful. If you can file the I-526 or I-526E, as well as the AOS, adjustment of status, then as long as it's been properly filed, As long as the AOS is waiting in front of the immigration services, you can then lawfully remain in the US patiently waiting for this to happen. Even if your initial non-immigrant visa expires or non-immigrant status expires, the pending AOS allows you to remain here. So that's very important. It's flexible, and it is also likely to be time limited. It's possible certain countries may have waiting lists, but we'll go into more details about that a little bit later. Next big step, you file the I-526, which for rural projects takes a shorter time, it's faster. Regional center, we're currently seeing maybe a year and above processing time. Rurals are somewhat faster. But upon I-526 or I-526E approval, then you can adjust status if you're in the US, or if you are not in the US, you can then have consular processing for a visa stamp at a US embassy or consulate. And both of those take you to the same end state. That is a 2-year conditional lawful permanent resident card, a 2-year green card. And then within the final 3 months of that 2-year green card, you must also then file an I-829 application to remove conditions. That turns your conditional green card into a permanent unconditional green card. Once that is approved, you then hold an unconditional green card, which lasts for 10 years, and every 10 years you have to revalidate it and file it with immigration. Now, your money, that is the second major part of the puzzle. What happens to your money? Well, your money must stay invested for at least 2 years. That is immigration requirement. And they've recently, in August or September, they clarified what they mean by that. And they mean 2 years measured from the date of investment and filing the I-526E. So on the first day that both of those conditions are true, you count from 2 years. So that now helps clarify things immensely. For the previous decade or so, 15 years or so, they did not clarify what they meant by 2 years. So there was a lot of uncertainty. Now we know. Next slide, please. So for the EB-5 standalone investment, very quickly, an investor invests in a lawful for-profit business inside the US. This contemplates the investor will be very closely involved with the process. So the investor will have to handle determining the targeted employment area, if that's what they want. They can and usually do closely manage the business on a day-to-day agenda. Oftentimes they're even sitting there at a desk in the business, and they're creating 10 specific full-time jobs of warm, living, breathing human beings. So these are literally 10 full-time jobs or higher. However, filing the EB-5 does not give you the right to be in the US. You would have to find some other way of coming in, and the most common one is the E2 that we'll talk a little bit we'll talk a little bit more about later on. The E2, simply put, is kind of like a temporary work investor visa. The EB-5 is more like a long-term permanent green card that takes a longer time to adjudicate. And as we said before, the standalone investment only allows one EB-5 investor. You cannot pool funds with multiple foreign friends and hope to get EB-5s for all of them. That is not permissible. Then the second option, the much more popular option, is a regional center investment. And this is where an investor subscribes with a large-scale existing product to pool funds with other EB-5 investors. Usually, the regional center already takes care of the TEA, already takes care of figuring out if it's rural or high unemployment. And the regional center will also help manage the business creation, business job creation, and management. And they can use econometrics to calculate job creation at higher level volumes. So simply put, what that means is if you invest in a regional center with, say, 100 other EB-5 investors, well, that's $80 million US right there, minimum, that they're working with. They probably don't have time to measure each individual hard hat on the construction area or each pair of boots on the ground. Instead, immigration allows regional centers to abstract the job creation from money in to job creation out. Next slide, please. So let's talk a little bit more about the standalone investment. Next slide. This used to be called the Direct EB-5. Recently, they renamed it. So now in 2022, it's called standalone. You'll still hear some people say, oh, I did direct investment EB-5, but that's all in the past. Let's jump to the next slide, and we'll talk a little bit more about standalone investments. So the structure, we have here the investor at the top. They must make lawfully sourced investment funds into the new commercial enterprise. And the new commercial enterprise then can itself create 10 full-time jobs, if that's what's preferred, or they can give the money to job-creating entities, which are separate entities. One very important limitation, the JCEs must be 100% wholly owned subsidiaries of the NCE. So if you do if you do give it to company A, which gives it to company B must be 100% owned by company A. It cannot be part owned by other companies or other investors. So that's just one important thing to keep in mind. And then you want to create 10 qualifying full-time jobs. You're actually going to track the people individually. Where are they? Where are they sitting? Where are they working? And try as much as possible to make sure that where they're sitting or working is inside a TEA if that was part of your plan at the initial stage. Next slide, please. So the petition process, you file the form I-526, not the E. This gives you an EB-5 priority date. Again, if you're in America, and if there's no waiting list for your country of birth, you can also file a 485. And the pending 485 lets you stay here without getting any further unlawful presence, but it also allows you to apply at the same time for a work permit and for a travel permit. So for a lot of people, say if you're if you're an overseas student at a US university on an F1 and your parents give you $800,000 to invest, you could conceivably file the 526 and also file the 485. While you study, you have the 485 pending, and you can also apply for a work permit, which lets you work on the pending EB-5. So very flexible. It gives you a head start, a jump start to starting your life in America and putting down roots. However, stage 2, if there is a waiting list, which there currently is not for any country as we speak, which is November 2023, if there is a waiting list, you must wait until your priority date is current for your country of birth. So until it's current, you cannot file the 485. Right now, there is no waiting list for new EB-5s. For old EB-5s, you can check online. There are quite a few waiting lists, but those have already closed. And now if you file an EB-5, you're under the new categories. The word around the campfire, the guess of the industry, is that EB-5 probably will not have a waiting list until possibly late next year, late 2024. So fingers crossed. If this is something you're interested in, then time is of the essence. If the investor is outside of the US, you must go via consular processing and DS-260. That involves an interview at the consular post. And then, as we mentioned, there's a conditional lawful permanent resident card for 2 years. In the final 3 months of that 2 years, you must file the 829, and then you get a permanent green card after that's approved. So that is the standalone petition process. Let's jump to the next slide. Then a regional center. This is where you pool your funds with other EB-5 investors. And the next slide after this, let's jump to that, and that will show us the structure. Now, this structure looks very similar to the standalone structure, except over in the upper left-hand corner, you can see there is a regional center. So the regional center is going to be a key part of this, and that is what lends the classification for the new commercial enterprise to be included under the regional center designation for immigration. The new commercial enterprise typically gives the money to a job-creating entity or multiple job-creating entities, and they then create 10 qualifying full-time jobs. As mentioned before, this can be abstracted via econometrics. Very useful if you don't want to keep, if you don't want to worry yourself about the individual tax details of every single employee. Sometimes these can number to the thousands or tens of thousands. Let's jump to the next slide. Pooling investments. So a regional center, as we mentioned before, this is a designation, that the Immigration Service gives to basically any business that has applied for one. However, this is a very lengthy process. It takes about 2 years to get a regional center designation or more, with the end result that is usually not worth your while to bother getting a regional center designation to apply from scratch. There are hundreds of existing regional centers, and regional centers are allowed to include new projects under their aegis, under their umbrella. So it is much more common for you to find a project you like, and then that project has already teamed up with a regional center. Regional centers usually charge an administrative fee. And if you do go with a regional center, this might be perhaps ballpark 10% of the ultimate investment amount, 50,000 to 80,000 and above. Those are fairly typical for the industry. Immigration has said that this extra administrative fee for the regional center must also be included and disclosed in the lawful source of funds analysis. So then the rest of this is fairly similar, but money goes to the NCE. They receive your investment. They then give that money to the JCE to create jobs. And then you need to work your way through many contractual business investment documents, some of which are listed there. We don't have time to go into those right now, but obviously your immigration attorney, if they're experienced with the EB-5, should be able to help you walk through those and give you an idea of what elements are important from an immigration viewpoint. Let's jump to the next slide. Accompanying family members. This is important. They can be included in the green card. You can include a spouse of any age, only one. And you can also include children who are unmarried under the age of 21 at the time of 485 filing. Note also that if your spouse is born in a different nation, you might want to consider which nation they're born in and which nation you are born in, because if one spouse has a wait list for their nation, they may use, in certain circumstances, the nation of the other spouse. Aside from that, there's a separate issue about children who are nearing the age of 21, because you do have to add in extra time for the whole processing, the legal process to go through. So that's something just to put a bookmark in that. If you or somebody you know has a child who's getting close to 21, talk to your immigration attorney about that and they can help. Next slide, please. The source of funds, just a couple of bullet points as I'm getting close to the end of my permissible time. Common source of funds is employment or entrepreneurship, or liquidation of assets, property, real estate, stock, or loan issued on assets. If you own a nice house and the bank gives you a loan for it, you may use that. Less common is cryptocurrency, monetary damages from lawsuits, life insurance policies, and so forth. Those have been filed before, but they're less common, and perhaps immigration services might be a little bit less familiar with those. But one thing is certain, all of these funds must be owned by the investor. Next slide, please. Then we get to the removal conditions. This is the final step. A couple of bullet points are on there. Note that you don't have to create, this is the part, the removal conditions, where generally speaking, we're hoping you can prove you created 10 jobs. Remember, the first step, 526, is saying, I plan to create 10 jobs and I prove my money is lawful. The 829 is proving afterwards, hello, you gave me this, you approved my 526, you gave me a temporary green card. The 829 is now saying, I delivered my promise to you, Uncle Sam, to create 10 American full-time jobs. All right, let's jump ahead. There are synergies with other visa status categories. I won't go into too much detail. The most important one is the E2 treaty investor synergy that my colleague, Attorney Jean, will talk about. You might want to take a quick screenshot of this about H1Bs, B1s, and F1s that might dovetail very nicely with the EB5 category. Let's jump ahead, please. Next slide. Very good. We have reached the end. That is a thumbnail sketch, slightly hurried overview of the EB5 process. Bear in mind, this is an immigrant visa application or an immigrant status application. It does not give you lawful status to be in the US just because you applied. You need to actually have another lawful status to come here. But if you are in lawful status and you file and there's no waiting list, then the adjustment of status gives you like a placeholder. It puts your finger in the book as a bookmark or holds your place in line as a bookmark, and you can then remain in America. Or if this is a very long-term project for you and it's not really important for you to come to America right away, you can file the EB5, remain outside America, perhaps managing your business overseas. And then when the time is right, then you have a conditional green card and you can come to the US and get started on your American dream then. Thank you very much for your time and your attention. And I'll hand it back to Raju, our Master of Ceremonies.
Thank you so much, Benjamin. It was a really nice presentation. I hope our audience, they paid attention so that they could understand everything. But if they did not pay attention here, it's okay. They can always reach out to you. They can always reach out to us. We will try our best to help them. Thank you, Benjamin, again. Now I would like to invite John Yan. He's an associate attorney in our firm. He will talk about E2 treaty investor.
Thank you, Raju. Good morning and good day, everyone. And good evening for those listening from Asia. My name is John Yoon. I work with Raju, and we also work with Benjamin. So if you want to work with any of us, feel free to give us a call. We have our information up and on the slides. I'm going to do a presentation on the E2 investor visa. As you'll see, it only applies to certain countries, but after this presentation, you'll see that we're going to do a question and answer session. So please do stick around if you have questions. As you'll see from the first slide, this is only limited to certain people from certain countries. So first, as Benjamin explained, the EB5 is pretty much available for people from most countries around the world. Of course, if there's certain illegal activities going on, we don't want to encourage that. So if there's any kind of those activities, you would be excluded. But the E2 is basically even more restrictive. As you'll see, it's somewhat easier to process, but it's only limited to specific countries that are listed in the State Department website. And you'll see, I did put this doesn't include all of them, but I did include a list that has some countries like Australia, Bangladesh, Bahrain, South Korea, Pakistan, and Senegal, Togo, Turkey, and the United Kingdom. So some prominent countries that we want to note that are left out would be like Brazil, People's Republic of China, India, Indonesia, Iran, Nigeria, Russia, UAE, and Vietnam. So generally, you cannot use the E2. If you have multiple citizenships, please do contact us because it could vary, depending on your citizenship situation. And we have been seeing, some clients that could have multiple citizenships could apply depending on which citizenship you have. And the next slide we'll go over. Next slide, please. So slide 2. Generally, EB-5 is pretty challenging, as Benjamin, explained. There are a lot of regulatory requirements. It does give you an easier path to becoming an immigrant. I don't know if this has been explained before, but the green card is technically the card. It used to actually, many years ago, it actually used to be green. So that's why we call it the green card. It would pretty much lead to permanent residence. The E2 is a little bit easier, as you'll see, but it's a non-immigrant visa, which means you come in and you technically have to have an intent to depart. So you set up your business, and it is basically like a 2-year, conditional visa that you come in for 2 years, and you do have to renew it every 2 years, which can be a little bit more challenging in some ways, but also can be easier in some ways. So that's why we want to give you this presentation. And next slide, please. So as you can see in slide 3, the EB-5, honestly, for most people, will require an investment over $1 million. The very basic minimum, as Benjamin said, is $800,000. But with fees and everything like that, it's usually ends up being over $1 million. The E2, it doesn't actually have a specific amount that we're looking for. We do look for a substantial amount and usually recommend over $100,000. Like the EB-5, the funds must be traceable. And I don't know if this has come up before, but we highly discourage any use of digital coins in terms of transfer. These funds should all be traceable and, of course, legal funds. And after you invest in the enterprise, you do have to be in a position to develop and direct the enterprise. And we recommend this for people who do have some executive or supervisory skills. As you can see from the EB-5s, it's could be a bit more passive in that you could send your money to a regional center, but the E2, we do really recommend that you're actively and directly involved in this enterprise. Next slide, please. And slide 4, so EB-5, it generally does take a little bit longer to process, and there's greater scrutiny of funds because when you do adjust your status, as Benjamin said, it makes it a little bit easier to become a permanent resident just because there's so much scrutiny in the beginning. But the E2 is often completed faster. We don't guarantee a specific time because a lot of the processing is often done at the foreign embassy or consulate. Sometimes we've actually had, people print out the documents and we direct them, which office to go to in their country. So it could be easier in some ways, but also you do have to, in many cases, go to the physical office. So, as we said, the results can vary depending on which country you're processing. Next slide, please. And as Benjamin said, for job creation, generally for EB-5, we're aiming to create 10 full-time jobs. And depends, obviously, as we said before, if you do a direct or regional center investment. For the E2, there isn't a specified requirement to create a specific number of jobs, but this is, you are trying to substantially develop the enterprise, that you do have income that's more than enough to just basically be a marginal amount that supports you and your family. We're basically thinking that, you're coming to develop business in the US, and that's, why the US wants you to be able to come here. And again, this is, non-immigrant intent visa, but basically you are trying to develop the business as much as possible. Next slide, please. So this is my email, and obviously the info at Raju Law goes to Raju. We do have paralegals and legal assistants that basically can work with you 24/7. So even though we're based in the United States office, we do have assistants in Asia, and we're happy to take questions. Benjamin, I think, will be around for the rest of the hour, and thank you, Raj and Benjamin.
Thank you very much, John, for your great presentation. Now the floor is open. If anybody has any question, please, you can ask us, or if you do not have any question, Benjamin or John, if you would like to add anything, we're happy to, add something. So yeah, now it's like an open floor for everybody.
Where would the questions show up? I'm new to this.
The question will show up on the screen. So first, they will ask the question in our system, and Samir will display that on the screen.
Okay. I wonder if we should take this time to troubleshoot a couple of common questions, FAQ.
Yes. Sure. Yes. Okay. Go ahead.
All right. So one of the nice things about E2, I wanted to supplement John's excellent presentation. EB-5, you got to file with the Immigration Service first. You're going to say, Uncle Sam, here's my plan. I'm the man, and I want to create 10 jobs. And then USCIS, Immigration Services, will then hem and haw over it, and then they'll process it. All right, here we go. I have B1, B2 visa along with my family. Can I apply for an EB-5 visa from within the USA? And the answer is potentially yes. In 2015, in July 15th, there was a circular, there was a presidential directive that then President Barack Obama put out that said B1s, which is a business travel visa. You come to America to kind of attend conferences and shake hands with people and sign contracts and start up business organizations. The B1 is entirely compatible with EB-5. Okay, so the answer to that is yes, it is possible to do that. However, after Obama, we had another president, and the subsequent presidential administration came up with a difficult rule that said, if you enter the US on a non-immigrant status like a B1, B2, then we expect you to maintain that non-immigrant status in all of your behavior for 90 days, 90, so for 3 months. So exactly how strict that is, people haven't really wanted to test that. Immigration lawyers necessarily want to be conservative, especially if your travel visa is on the line. But the long and short of it is that if 90 days pass from the last time you entered the US on a B1 or B2 or a non-immigrant visa, then it is possible for you to do things like invest in an EB-5 and to file for an EB-5. That is potentially possible, and would be unlikely to encounter obstruction or problems, especially as this rule came about one presidential administration ago. It's not the current presidential administration. So the answer, unfortunately, is not really clear cut, but it is possible to do that. And if you file an EB-5, so the I-526 with the 526E, if you're going with regional center, say on day 120, so 4 months into your B1, B2 stay, well beyond the 90-day, 3-month period, you could file that. And if there is no waiting list for your country of birth, then you could file an AOS for yourself and include a spouse, only one, and children who are unmarried and under 21, and they also can have adjustment status as well. And that adjustment status filing then allows all members of your family who have filed adjustment status to remain in the US and not gain unlawful presence, even if the original B1, B2 stay has reached its end. So usually B1, B2 allows you to enter, say, for about six months or thereabouts and no more. If you filed an EB5 lawfully, and if you filed an AOS correctly, then that filed AOS lets you stay even beyond that 6 months. And there have been people who've stayed here for quite a long time on a pending AOS, just patiently waiting for that process to come through. The AOS also gets you a work permit and a travel reentry permit too. So those are nice bonuses, especially if you want to actually work and kind of support your EB5 that way. Anything else to add? I'll open it up to our other two gentlemen. If nothing to add, next question. What does it mean that funds should be traceable? Good question. Good question. So immigration requires evidence and documentation, and the level of evidence is preponderance of the evidence. And that's a weird English word that means more likely to be true than untrue. So more likely to be true means anything above 50% likelihood of being true. So you need to trace your funds. You need to provide documents to say that these funds came from a lawful source. So a very common example that we'll see is, here's a student in America in college. Mother is a millionaire, father is a millionaire, and mother and father say, son or daughter, we will give you all the money you need to do an EB5. So here is $900,000 to do a TEA, or here's $1.2 million to do a non-TEA, accounting for fees. And then you've put the money into the relevant investment and you file the I-526. The funds need to show that, number one, the investor owned them. Number two, everywhere they came from, you go back up the tree, the stream, go back upstream to the source and find out whether or not it was lawful. So if mother and father are, for example, high-powered accountants with transnational consulting firms in Dubai or Hong Kong or Singapore, which is also fairly common, then they may present several years of their salary and income. Say, hey, if you total up all of this money, it's $2 million over the past 3 years or whatever. So obviously you can afford the $0.8 million or $1.05 million to make the investment. And then any added documentation that your lawyer works with you to prove that they really are lawful. So often this will be bank documentations for years, tax documentation for years. This part, the source of funds, can become very complicated. I've worked with Chinese families and Indian families where, to support one single investor, there have been a handful or dozens of family members involved, each of them selling property and giving the money to the investor. So for every single person, you have to go back and say, well, how did you get this property that you're selling or that you're mortgaging? Where did the money come from to buy it in the first place? Did that money come from your work? Do we have proof of your work there? So in those situations, sometimes the path of funds, the source of funds, historical documentation can go back a dozen years or so. It's not unheard of that to happen. Raju, John, any other thoughts?
Yeah, so one of the main question people ask me all the time, like, what do you prefer as an attorney? Regional center is better or investing by yourself is better?
So as the attorney, looking at this from someone who would be giving advice to someone who wants to navigate the immigration process successfully, the two categories serve very different tastes of investors, like investors' preferences and investors' situations. So the standalone or direct is the American dream, a foreigner like Nikola Tesla or perhaps Albert Einstein, maybe. Elon Musk, perhaps. A foreigner who has a brilliant business plan and a lot of money comes to America and they have a plan to start up a business in the US. So that would be standalone or direct, because you can't bring any other foreign partners with you. They can't get EB5s, just yourself plus your family, spouse and children. So that's standalone. And that would also be beneficial for somebody who really knows what they're doing business-wise and really has a very specific idea of how they want their money spent. So that they're happy to kind of be almost like the CEO or the chairman of the board and say, this money goes to that company, this money goes to that company. I want this company doing this, and I want this. Here's my first quarter plan for that company to create 2 jobs and then 5 jobs and then another, 3 jobs at the end. So that's standalone, somebody who's really hands-on, often day to day. Regional center is different. Regional center is almost like a separate team, a separate entity that you entrust with your money, and you make your investment into that regional center, and then that money then goes internally to other businesses that have very specific plans. But the specific plans are not adjustable by you. They are not tailorable by you. They're not a bespoke suit that your tailor makes for your specific plans. This is kind of off the shelf. Your money will go into the account and it will be used for business activities alongside dozens or even hundreds of other EB5 investors, all seeking the same goal as you. And so it is a solution for somebody who is not particularly closely involved with a business and doesn't want to be closely involved with a business. It is for somebody who, for example, says, I'm in America, I'm a foreign student, I'm doing this degree and I want to live here for the rest of my life. And I want to make a contribution to the American economy, but I don't have a degree in economics and I'm not an MBA. I don't know how to do it myself. My contribution instead will be to people who know what they're doing. Hopefully you find a regional center and a project management team that has many years of experience, and you can look online and check their background and say, they've done these projects and they've resulted in this dozens or hundreds of green cards that have already been approved. And it requires that leap of faith, that business trust, that you entrust this other organization with your money to create the jobs, to turn a profit, and to give you your money back at the end of it. So that's a long way of saying, Raju, that I can't really say one is better than the other. It's like, do you want to, I don't know. It's like, do you want to form an incorporated company, or do you want to form a limited liability company? It depends on your situation, right?
Right. I can give some examples too, if you want.
Go ahead, John.
So for example, things we've been seeing in the EB5 field are very large, like hotel projects or like a resort that requires, millions of dollars. So they can't just have one EB5 investor. So sometimes they'll pool, like Benjamin was saying, 10 or 20 or maybe even 30, like dozens of investors. And some people just would prefer to do something that's kind of a bit more passive and, send the money over and kind of make it a little bit easier for them in a way to invest. Some people prefer to have, more control over the money. And that's one of the reasons they would prefer to do a direct investment. And to be clear, if you're interested in working with me or Raju, we also handle EB5s, and we can work with Benjamin. We all work together as a team. One thing we didn't mention enough times probably was that we do not function in a financial broker dealer role. So we don't force you to go to one investment or the other. We're pretty open-minded in terms of what kinds of things, whether it's, restaurant, gas station, service center, there's multiple opportunities. Once you go into EB5, in a regional center, you kind of have to pick and choose and go along kind of more with their rules. And, like I said, you do have some choices in terms of EB5 or E2, but the funds, going back to the traceability question, we do want them to, of course, all be legal. And like Benjamin was saying, if you have 10 or 12 people come and invest with you, they can give gifts as long as they're promissory notes that are written out. And we do, trace back into, if you sell real estate, where those funds are coming from. We just want to make sure that, all the funds are from a legal source. And if you do have that, you don't have to worry if it's coming from multiple friends or even family and things like that, as long as you have, notes explaining, where the funds are from. And, we're pretty flexible in that respect.
Thank you, John. I have a question to both of you. Yeah. So let's give you a scenario. So let's say one foreign person wants to build a like an apartment complex or buy a very expensive home, let's say in Potomac, Maryland. It's a $1 million home, and he hired like 10 people as a manager, as a cleaner, as a other thing, and he is renting this place as an Airbnb. Does that qualify for EB5? At the same question to John. So let's say somebody bought a home for let's say $200,000 kind of home somewhere in America, and he did not hire a lot of people, but he's still renting it to Airbnb for people to go stay and make money. Does it qualify for E2? So Benjamin, you first go ahead.
For EB5, that's an excellent question. For EB5, the new 2022 update to the rules, they have actually clarified that setting up your own household and hiring 10 staff members to manage that household, even if it's full-time, that does not qualify. So they expect that this is going to be a lasting contribution to the US economy and is not merely localized to the investor and to sustaining their standard of living. So the added detail about Airbnb, that's a cute little detail. It's full marks for ingenuity, but I would say that that is likely to fall afoul of the Immigration Service's stated intent that they do not consider personal household maintenance to qualify. It's supposed to be an investment into just the general economy in a specific project, but it's not really supposed to be just me, myself, and my family, my household.
Okay. Same scenario, just instead of like a one home, if one person build like a apartment complex, not like a super giant apartment complex, let's say like bought a land, like a commercial land, and then like a 10-storied building or like 10 units of apartment complex and made like a LLC or incorporated, does it qualify for EB-5?
I think that would be significantly closer towards falling into the category of validity, yes. Obviously, this is very general in the very abstract, but that I think would take it more confidently out of the realm of just one investor and their family. And this is more an actual contribution towards the community and something that actually benefits the entire economy.
Right.
Thank you. John, go ahead.
Sure. It reminds me of some other things that we didn't talk about that much. You can find this, on the internet pretty easily, that when you do set up the E2 or EB-5, you do want to have all the paperwork and set up, your corporation and, do have all the paperwork set up. We can help you with that. There's not necessarily, a specific way to do that in terms of E2 that's more or less difficult. It's just, when you set up the corporation, you do want to do it in the proper way. And in some ways, E2 is a little bit easier, but you do still want to set up, the corporation so that you're not doing, as Benjamin said, you're not doing these things in a personal, as a personal residence. So you do want to set up the corporation and then, do all the banking. And we can definitely help you with that. We have a huge team of paralegals and legal assistants that can help. And yeah, I'm happy to take more questions.
Yeah, thank you very much. Yeah, go ahead, Benjamin.
I think that John touched upon a very interesting point. And we were talking about E2s, which are the temporary, quick, but term-limited, renewable non-immigrant status. And that doesn't really have a specified minimum amount. It's just a substantial amount. And EB-5 has a very specific minimum amount, 800,000 or 1.05 million. It is not unheard of. And in fact, if the person's conditions support it, it's actually a fairly ingenious and synergistic arrangement to do one single transaction, one single investment transaction that qualifies for both the E2 and the EB-5 at once. So if you come from a country, you have a passport from a country that allows you to do E2, then you could potentially structure one single transaction, one single investment that satisfies the EB-5 minimum amounts and also satisfies the E2 requirements and also has the 10 job creation. And then on the strength of that one single transaction alone, you can have a fairly speedy, fairly quick E2 status that brings you here to the US, allowed to legally work here. And then it keeps you here lawfully until you wait for the somewhat slower EB-5 process to finish. The one slight drawback about that is that the E2 investment usually is going to be closer towards a standalone EB-5. It's difficult to make a regional center EB-5 investment qualify for E2 because E2 requires no minimum amount, but it must be a substantial amount of funds compared to the entire business entity. And for EB-5 regional centers, those things are tens or dozens or hundreds of investors large. Is there any chance to change E2 to EB-5 visa after 2 years? Yes. that is like perfect. That E2 to EB-5 transition is almost like the golden goblet of what we're looking for in immigration. You'll find that a lot of immigration green cards, the permanent green cards, have kind of like a little brother, little sister kind of non-immigrant status that's a little bit less demanding, a little bit faster to get, but doesn't last as long as a green card does. It's temporary. So E2 is kind of like the little brother of EB5. You can certainly do E2 and then try EB5. Now, if your E2 transaction does not support EB5, you may need to top it up. So for example, if you invested $200,000 to E2, and then you want to contemplate an EB5 later on, you might need to add in extra money so that that arrangement now satisfies EB5. So that's something to keep in mind, but yes. Someone is in Bangladesh, how can they start a business in the US? Well, you want the legal answer? You want the legalistic answer, or like the practical answer? Legalistic answer is Raju and John. I'm sure would be very happy to say.
Yeah, let me help you there, because I helped. Let me answer this question. I help some people, like a few people, setting up business here in America from Bangladesh or even other countries. So the good thing is America is a very business friendly country. You can open a business here in America from anywhere in the world. So that the minimum requirement is that you have to start a business somewhere in America, some state, and you must have an authorized representative in that state. So let me, look, I live in the state of Maryland, which is right next to Washington, D.C. Let's say if you want to start a business in Maryland, you can easily do that. You just need an authorized representative who is living in the state of Maryland. The good thing is there's a lot of business, a lot of corporations, they can work as your authorized representative. So either you or your attorney must hire a authorized representative, either a person or a company, to represent you. That's the only minimum requirement to open a business. Now, the good thing is, if you have a visit visa, you can definitely come to America, open a business, open a bank account, open everything, and then you can go back to your home country. And you can operate your business from your home country. There's no problem with that. So the short answer to your question is that, yes, you can start a business in any American states from anywhere in the world. You just need an authorized representative to, kind of like have like a communication between you and the state. That's the basic minimum requirement. But otherwise, it's very easy. Benjamin, if you want to add anything?
No, I think that's it. That's the legalistic answer. That's a process that you need somebody who answers to you, and it can be a purely business agreement. And they're there to receive mail and receive phone calls from the state, and they'll pass that information to you. Now, the actual practical issue of getting your factory set up and getting all those things set up, that's a little more difficult, and you might want to talk to a lawyer about that to see what immigration statuses you can come to the U.S. on.
But all the people who took my help about setting up business here in America, they don't have like a factory or any kind of physical location. They mostly do like a consultancy kind of business. So one guy, he's a software consultant. He opened a business here in America in the state of Maryland, and then he provides support to other businesses. Like let's say you are a law firm. You have a law firm. If you need like any software, anything, you will take their consultancy. In terms of like finding the appropriate software, how to hire a software engineer to blah blah blah, and then you will pay the company, and the money will directly deposit in the bank account. So they don't need to have in any factory or any physical location. Everything is online.
Yes, it's a brave new world we live in. I think we had a question pop up about how many days are needed for the full process of the E2 visa applying from inside the USA. The E2 visa is not commonly applied from inside the USA. You can do it, but it's more commonly applied outside the USA because there's an expedited or potentially expedited process where you attend a visa interview with all of your paperwork in your hand, and they adjudicate it on the spot at the visa interview. If you're inside the US already, you can change to an E2 status, say if you're on a student status, F1. The change of status is the 589 process, and that takes a fairly long time. Immigration services is not as fast as the embassy and the consulates are at doing E2s. The most recent one that I did took somewhere in the region of about 5 to 6 months, and that was already considered fairly fast. During the height of the pandemic, it was much, much longer. You may apply for consular processing outside the US, even if you are inside the US. You just sort of say, I in future plan to leave the US and go out and get this non-immigrant visa. That would depend on your nation, which nation you want to apply for the E2 from. Some nations let you show up in person with your stack of papers and they'll adjudicate it at the interview. Some do not. Some require you to file something formally with the immigration services first and inside the US, and then they'll look through your papers there and then pass it to the relevant embassy post.
Right. I'll chime in too for the E2. It does depend so much on the particular country you're coming from. There's so many different rules. That's why we didn't outline them. You know, one country is very different from another country. So that's why we didn't outline it. But just real quick too, a lot of the lines are kind of being reset also for EB5. And then we'll get to this question. So it's kind of like with this new law that Benjamin mentioned in 2022, everything kind of got reset. So there's like the government made a new line, and that's why we're doing this presentation, is that there's this new opportunity to come and, you know, invest in the E2 or EB5. And we're basically setting up this new line. But this is more in particular for the EB5, that you want to be current in the specific line to kind of get in the process. And we'll go ahead and take this question because I think we might need to wrap up in a few minutes.
If I open an account in the USA and deposit the money from Dubai from another person's account to my account, is it acceptable? Ooh. This is something that will absolutely be scrutinized by immigration. Immigration is certainly very, they will go into detail about things like whose account moved the money to whom. The question is, it is permissible for money to move around other people's accounts, especially if they gift the money to you. Say your parents give you money, that's fine. But generally speaking, before the money goes into any business activity that is trying to get you an immigrant or non-immigrant status, that money needs to be in an account that you own completely. So for EB5 and for E2, before you make your investment, they expect that you're going to have an account or accounts that you are the sole owner of. Slight exception, if you're married, your spouse can also be co-owner. But you are sole owner of it, possibly with a spouse, but nobody else. And therefore you control that money, therefore the money belongs to you. So this question, I guess we would need more clarification, but we want to avoid a situation where there's a new commercial enterprise that's receiving your money and you put in 50% of your money into that from your account, and then your mother sends 50% to that company from her account. That will cause problems. And I've seen EB5 cases get in trouble with that, where immigration says, we don't believe that this half money belongs to you, it belongs to your mother.
Benjamin, before you read this question and answer, I would like to thank everybody. I got to go. I have another event very soon. I really appreciate everybody who joined today, who watched our video, and in future contact us. And thank you, Benjamin. Thank you, John. Thank you, Samir, for helping us from the behind. So, Benjamin, after I'm gone, you and John, you please decide how long you stay here, how many questions you want to answer, everything. When you're done, say goodbye, and Samir will end the session.
Understood. So I'm sad to see you go, Raju, because this next question appears to be for you.
Okay, I have a very important question. How will I transfer money from Bangladesh? So it's
the financial advice part, right? This is
exactly. So as far I know, the Bangladeshi government is not very friendly about transferring money from Bangladesh to America or any other country. They only allow $10,000 per year per person. So if you want to legally transfer money from Bangladesh, it's really hard unless like a 10 different person is transferring, let's say $10,000 each, and then all that and they have to be like family member or something. Otherwise, they have to give some explanation why they're giving money to you. So the short answer is it's hard to transfer money from Bangladesh, but definitely there are some options. And I cannot answer anymore at this moment. I really have to go. Please send me email. I'll try to answer this question through email. Thank you, everybody. Have a wonderful day.
Thank you.
And then just so we all know, the email for Raju, I think we have info@rajulaw.com, right, John?
Right, that's right. So in terms of transfers, and this is before what we were talking about with traceability, you do want to be very careful. You can transfer the money, but we want it to be traceable. We actually prefer bank transfers and kind of generally discourage things like Bitcoin or cryptocurrency because those are generally not traceable. So that's an example of things that we're trying to encourage versus discourage. If you do, have gifts from friends or family. We do prefer it informal, like a bank transfer that's very highly traceable, that people can see where the money's moving around, and it's kind of easier to explain where the money's coming from. And we'll take this question.
It's money transfer from Bangladesh. I think that this also it falls into the same category of Raju. It's best to speak to Raju for that.
Okay, and the E2 visa holder spouse. Yes, so the E2, when you come in on the E2, the main person, that's the business owner or director, gets E2, and it is relatively easier to get, spousal work permit.
Yes, spouses are allowed to work, and they do not have to work for the same company that the E2 investor has invested in. They could work for free. They could volunteer. They could work as a consultant for Tesla. The E2 work permit does not have limitations. An LLB degree from the UK, can you practice in the USA? No. Can you apply for an E2 visa? Potentially, yes. The UK has a somewhat different legal system to the US, and in order to actually practice law in the US, you would need to be licensed by a jurisdiction bar, which is usually a state bar. That would be similar to the Inns of Court in Britain. For an E2 visa, you could apply for one, but it would need to be through some sort of business activity that you were able to lawfully do. So if a person, say, for example, if a doctor or somebody who has a medical license in a foreign country wants to come to the US and wants to open up a medical practice, that's okay, as long as they're not the sole medical practitioner, because then it wouldn't be a lawful business. They would be practicing without a license. So it is certainly possible for a person with a foreign law degree to come to the US and get either a US law degree or to go ahead and take the bar exam of certain jurisdictions and then pass the bar, and that could be licensed. New York and California seem to be very attractive magnets for foreign lawyers to take. They also have some of the highest failure rates in the US, perhaps for that reason, that so many people are trying them. But that might be a place to start your search. I wish you all good luck in becoming a US barred attorney.
Right. I definitely agree with that. That's one of the basic things that we learn in law school is, if you don't have a US license, you do not want to practice law in any state. Some of the laws may vary in terms of, because we have 50 states, but that's generally, a thing that you cannot practice law without a license in the particular state. If you do want to set it up as like a business owner, obviously, consult with us, and you have to be careful. But if you're, the financier or on the corporate end as like an office manager, that could be slightly different. But yeah, generally you do have to, a lot of schools have like a LLM kind of program where people come in and have a, foreign license and then study here for a few years and then sit for what we call the bar exam and then get licensed that way.
A very large number of foreign trained lawyers come to the US and then pass the bar, and they go into immigration law, unsurprisingly. So that's you'll be the company of very, very fine people if you do that. Any other common questions? What happens if somebody invests in the EB5 and they bring along their family and they die? This comes up once in a while. If the person expires during the period of the initial I-526 before it's approved, then the I-526 cannot continue. So the rest of the family is unfortunately out of luck. It is conceivable that the spouse could then negotiate with the regional center to take over the investor's share. That is, we've seen that happen once or twice, where the regional center gave the money back to the spouse, and the spouse then reinvested. And then they have their own EB5 starting again from scratch. If you get past the I-526 stage, and then you have gotten the conditional green card stage, and people have the conditional green cards, then each member of the family has their own conditional green card, and they can then do an 829 individually. This can be important in the case, for example, where an investor comes in and brings along their spouse, and then while they're here, things don't turn out so well for the marriage, and they dissolve the marriage and they divorce. at that point, the spouse can still file the 829 because they have their own conditional green card. So at that stage, if the investor dies, spouse and children, as long as they have their conditional green card, can still go ahead with the 829. If the investor withdraws their application, they say, you know what, I don't want the green card anymore. I'm just killing the whole EB-5 thing. I don't want to do it. Then the rest of their family is out of luck. They fall out too. There's no way for them to file the 829 if the initial investor says, I don't do this anymore. So that was the issue of death. The other issue is the issue of taxes. And one of the things we always know is that once you get a green card, you have to report your global taxes. You have to report your global income to the U.S. government. We are not tax expert attorneys, so that's something you would have to talk to a cross-border tax expert about. But forewarned is forearmed, and we want to make sure that you have all the tools at your disposal. If you do get the green card, then you'll have to report global income. Does not necessarily mean you have to pay taxes to the U.S. In many cases, your home country and the U.S. may have tax agreements. And so if you pay taxes to your home country, it may defray, or in fact, it may reduce or eliminate your requirement to pay tax to the U.S. government. So that's, again, something else to talk to your CPA about and make sure you understand. But that is a real consequence. I did handle a heartbreaking case of one family that had 3 children, and they invested in the U.S. and they were all ready to go to the consulate and sit down and have their interview. And then they called us in a panic and they said, we've just been offered a job at blank. And blank was a very high level cross-border non-governmental organization that was kind of regionally involved with economic development in an important area of the globe. And the problem was that the tax consequences, if they had a green card at that time, would have quadrupled their tax or something like that. So in the end, they said, do I want to keep the job or do I want to keep the green card? They said, I'll keep the job. So they called us up and said, please cancel the green card process. And we're like, okay, we understand. We understand why you've done this, and we will tell the U.S. government that you're giving up your green card. But sometimes they can have very real consequences, and it's good for you to speak with your own experts to know what they are ahead of time.
Right. I mean, generally, I would agree with that too, because in E2, there isn't necessarily a way to extend it, once someone passes. So, and there's not that option of the regional center. So you do have to have someone that's really directly involved. And if you do want to ask us questions, Raju does have some free appointments available, but generally, if you do want to ask a really detailed question, we do encourage emailing or calling, and we do have an office in Bangladesh. I don't know if Raj had mentioned that actually, so they can also help out with the questions and the transfers.
Well, we have a question. This is very interesting, about studying in America first and then going into work and potentially becoming an investor. So if you come to the US and study, you are very likely going to come here on an F1. And F1, your campus will have a designated scholastic official, a DSO, who will go over all the necessary rules. They're a little bit beyond the ambit of this talk. You are allowed to accept employment, and it may be paid or unpaid, as long as properly authorized first while you study. So during the 2-year or 3-year JD program, you may work potentially. As a practical matter, I would say that it's actually difficult to fit work in. The JD programs are usually very intensive and they require quite a lot of brain bandwidth, but you might be able to fit in a job. Working while you're studying is called curricular practical training, CPT. And ideally, you should not work for more than 12 months of that. You are allowed to, but after you graduate, you then get something called OPT, which is optional practical training. And that is automatically locked out and eliminated if you've worked for more than 12 months of CPT. So that's one of the reasons why you might want to budget ration your CPT. But OPT can be in any field that is related to your field of study. So any sort of work that's related to your study. If you came here for an LLM and you get an LLM, you cannot, for example, get OPT to work as a waiter in a restaurant. That would not be okay. And your question then was, how do I turn that into E2? That would be possible but it would not be directly related to your student activities. E2 specifically contemplates that you are an investor of a substantial and maybe even majority interest in a US business. So it is doable if you're a student and if you came here and got a law degree, but it is not a natural progression of the law degree and law work. So you certainly could graduate, get your LLM, and say, my parents have a business that imports this particular gadget from this particular country, and they want to expand it in America, and they're going to create this company in America, and I will run it, and they're giving me money to run it and money to invest. That could support an E2, but as you see, the facts are completely separate from the fact that you have a law degree. Any tax deduction from the money sent for investment? Under the US tax regimen, that would be a very good question for your tax advisor or your tax attorney. John, I don't think I'm going to touch that one. Are you?
So yeah, generally, I mean, this is a tax law question, and honestly, we're not tax law experts. We can answer really basic questions. You know, it really depends how your business is structured, and you know what the money is for. So, for example, we've seen some people actually bring money into the U.S. and go ahead and start. You know, if they you know, there's some setup fees, like setting up your business and things like that, that could be deductible, and it's really depends on what the circumstance is for setting it up. If I can segue back to the previous question, actually. So for E2 and some of the EB5s, like a direct investment, I think the government does like to see things like a business plan, really specific investments, and kind of specific know-how, like supervisory and management knowledge. I think for that, something like a business degree would generally be better than a law degree, because most legal degrees, there isn't necessarily the business kind of management. I mean, we do learn about, you know, setting up a corporation and things like that, but in terms of running a business, I think a business degree would actually do a little bit better in most circumstances.
Yeah, that's very important. A business plan is vital for all EB5s. So
Right.
if you're doing something with a regional center, then the regional center will take care of the business plan because it's all already done by them, and you're just buying in. Whereas if you're doing a standalone, then they expect real nuts and bolts details, economic analysis report, business plan report, how you are going to create these jobs. And EB5 is very strict. You must create at least 10 jobs. E2 is not as strict, but the idea is still that you are investing and creating jobs. They don't really say how many jobs you have to create, but the expectation is there. That's not just for you and your spouse. You're actually creating job opportunities for American residents and citizens.
Right. As you can see, you know, Benjamin and Raj and I all get along. So I think, you know, we're happy to take any clients that want to work with any of us. And, you know, Raj and Benjamin, like they said, they're the co-chair of the Montgomery County, right? Bar.
Yeah, Montgomery County, Maryland. We are the county that Washington, D.C. is right across the border, and it has the largest concentration of lawyers of any city in the world, because they all work for the U.S. federal government or supporting law firms. And then we like to joke that Montgomery County sleeps more lawyers than anywhere in the world, because they go to DC to work in the daytime and they come back to Montgomery County to sleep at night, and they go back the next day. But yeah, so we welcome your questions, and Raju is very, very active in campuses and social media, very, very outgoing. And I had the good luck to be actually working in Guangzhou, China, for 3 years, from 2015 to 2018. And that is a city that America has put its immigrant visa processing post in China. So that processes green cards for all Chinese people. So for those 3 years I was there, that one post did more EB5 than any other location in the world, including the US itself. So it was a very interesting experience, and looking forward to sharing that know-how and knowledge with anyone who's interested today.
Okay, I think that's all the questions for today.
Yeah. I think so. You've been a great audience. Thank you all very much. And to John, kudos and thanks again for co-hosting. Hope everyone's learned something today. And we have our contact details. Please reach out if we can be of further assistance.
Thank you again.
Do you want to pursue a career as a paralegal in America? According to the United States Bureau of Labor Statistics, the median salary for a paralegal in America is $59,200 per year. With a growth rate of 14.1%, there were 54,300 new jobs in 2022. Join the Paralegal Bootcamp program under the direct supervision of top American attorneys and pursue your dream career as a paralegal. Not only will we educate you on the American legal system, but we will also help you find your dream job. For course fees and other information, please visit our website at www.paralegalbootcamp.us.